Hello, everyone. Welcome. My name is Kim Tran, Head of Marketing here at Gimmal. I am so excited to host today's conversation live with Tom Corey. Some of you may know him from ARMA and various associations, speaking conferences. He is an award-winning author and attorney as well in a past life. And I will be hosting him today to review 13 and now 14 U.S. state privacy law updates as of this week with New Jersey. And so we will be addressing what that means for you all and really for us all in the coming year. One big comment and question that came up ahead of attendees registering was, let's get some tangible actions that we can take from this webinar. We know privacy updates are coming. We know it's complicated. And yes, it's hard to keep up. And so with that said, let's dive in. Okay, well, Tom, I would love to hear a little bit about your background. You will do yourself more justice introducing yourself, I'm sure.
Well, thank you. And thank you for inviting me to be a part of this. And thanks to everybody who's joining. I couldn't be more excited. As Kim mentioned, my background is as an attorney, but I got into privacy through the information governance industry. Specifically, when I became an attorney, the area that I focused a lot on was creating records retention schedules. So that was back in 2010. And at that time, we really didn't talk a whole lot about privacy. There was a European directive at the time, but privacy wasn't a huge driver. And frankly, global wasn't a huge driver in 2010. But eventually, once we started to get these enterprise systems in place for organizations, we started to look at records and information from a global perspective, and that introduced us to Europe. And in 2018, Europe went from a directive to a regulation called the GDPR, and then we started to hear about privacy. So at that point, I went from information governance focused just on records retention to also incorporating privacy requirements, especially as the states in the United States started to implement and adopt some of these in other countries throughout the world. So that's why, besides being an attorney, I'm a certified records manager and a certified information privacy professional and certified information privacy manager. And I'm based out of Charlotte, North Carolina, where it is cold here too.
Thank you, Tom. And so the reason why, back and forth before we even kind of started shaping this webinar, last year, data privacy was trending, and it seemed like every other day there was a data breach happening across industries, across states, across companies. And so obviously there was a lot of fear, uncertainty, also confusion, and potentially, people not having a lot of clarity. And so I love that we have this data protection law at a glance, quick overview. And as of this week, New Jersey has joined the party. And so could you just walk us through a little bit about, all of the privacy acts and what that means for the rest of us?
Yeah, and at first glance, this seems overwhelming. I mean, we have 14 states, and we know that there's a lot of legislatures looking at adopting these as well. And as you look through the states, one of the things that really hits me is they're all over the country. It's not just an East Coast thing or a West Coast thing or a red state, blue state, or anything like that. It's across the country. We have states adopting laws and regulations that are there to protect people's personal information. And so as we start to talk about this, one of the things I'm hoping that people will see is that those actionable items, that despite the fact that there's so many laws and regulations, there's methods to make this not feel overwhelming. And in fact, I'm going to say something that's going to sound contradictory at first. And that is, the more laws and regulations we have on this, the easier it is, not the harder, doesn't make it harder. I think it was harder when it was just California and Colorado that had it. And you had to figure out, am I subject to California and Colorado rules, or am I subject to GDPR rules because we may have a customer in Europe? I think that when you start to see this, well, at first it looks overwhelming. I think as we look into this more, you're going to go, oh, well, this is going to be easier now that more places are adopting these laws.
I love that you're saying that, Tom, because now that there are more states, I think, like you said, they are becoming more similar than different. And I think with California kind of being that very first state out of the gate, so to speak, now other states are following suit. And so in your work, what are some questions that people are concerned about? What are folks kind of coming to you with, and how are you addressing those questions?
Yeah, at first, I think people come to me overwhelmed by the laws, and they tend to focus in on the laws. Oh, there's so many laws, and they're different. There's nuances to them, and that may be true. But instead of and I'm a lawyer, so you would think I would be obsessed with laws. But instead, what I try to encourage our clients to do is focus less on the law and start thinking about them in terms of a framework. Because here is the surprising reality. While we're getting more laws in regards to this, the reality is that the framework is there and the laws are becoming more similar, not different. It's not like you have these totally different approaches to privacy in the various states. They're working off of each other to create this common framework. I know that a lot of people say, well, there's no federal legislation for all data protection laws, and there isn't. But right now, the states are kind of building this framework that most organizations can follow and use and implement. So if anything comes out of this presentation, it's not to feel overwhelmed, but to feel some comfort that if you kind of adopt these actionable items that you talked about, Kim, that you're going to be okay, that there's ways to do this and not feel overwhelmed.
I love that. I feel like you're doing a bit of a life coaching moment here. But speaking of common framework, I know that, sometimes a lot of our audience members on today's webinar, but also a lot of our customers don't have legal backgrounds. And so for me, it's very reassuring to hear that from you, to focus on the common framework and to feel less concerned about the laws themselves, but really focusing on what people can do. And one common question that folks, worry about on our side is who is responsible for what. And so, but let's start off with the basic framework first.
Yeah, so if you look at most of the laws that are coming out, they usually have 4 sections to them. Who's with the scope, who's covered, who's responsible for following those laws. Once again, on these general data protection laws that we're seeing through the states, they're going to have these qualifiers. But now that most states are implementing those, it's a little bit easier. You can say, well, we're just going to follow many of those requirements because it fits within a common framework. Then the next thing that the laws will do is they'll talk about what the rights are of people, because essentially that's what a Personal Data Protection Act is. It's about really telling consumers, and consumers are individuals, whether they're employees or actual consumers or anybody who you hold the data on. It's about them. It's about protecting them. It's about advocating for them. And it's about saying, this is your information. In a way, this belongs to you. So the laws will define those rights. And then they'll talk about, now that we know what the rights are of the individuals, the businesses or the organizations that hold that information, you have certain obligations to allow people to enjoy those rights. And then the last section of most of these laws is, how do we enforce it? What is the mechanism for enforcement on that? So we'll go into a little bit more detail on these to understand, but that's basically what most of these laws, yes, they're many pages long, but essentially that's what they're focused on.
Thank you for that. And I think, again, now that we looked at the common concerns and what's top of mind, and now we have a basic framework, the next question is, who's responsible for what? And speaking as a marketer, we deal with a lot of data, and data protection is just as much my job and responsibility than anybody else and any other function in the organization. And it's really about bridging the gap, and it's really a mission possible, which I like to say. And so everyone from compliance to risk management, information governance, and legal. And in your role at Harbor, you deal with all of these functions. And so could you talk us through a little bit about, how that common framework that you just shared would fit within these different teams and how to work with these teams, perhaps?
One of the reasons I think, coming from an information governance background was so helpful for privacy is because information governance and privacy share something in common. They're an enterprise-wide function. And that's what privacy is. And, I was asked for legal tech, what is my prediction for privacy in the next year? And my prediction is that privacy will no longer just be jammed into a various function. And when I work with clients, that is a very common thing that I'm seeing in the United States, not in Europe, but in the United States. I'll see them try to jam all the privacy stuff into one group. Like they'll jam privacy into compliance. Well, compliance has a role in privacy because you want to follow the laws and you want to follow the workflow. That's fine. But compliance themselves, their ultimate goal is different than privacy, because privacy needs to also be an advocate for the consumers. Risk management plays a role in privacy because you have cyber insurance, you have ways to mitigate the effects of breaches. So it's very important, but it's not the entirety of privacy. IT plays a role because so much of this information is in electronic systems, and they have to be able to manage this through data maps and various functions, but they're not the entire privacy function. And legal, well, legal deals with issues. They're not very, as a lawyer, I can tell you this. How often do you say to yourself, boy, that lawyer is a good project manager? It's not very often. And there's a reason for that. As a lawyer, we're trained to focus on issues, not process. And privacy is as much about the law as it is about process and management. So legal has a role in this, especially when it comes to how they deal with third parties and contracts and making sure that the laws are complied with, but they're not the entirety thing. So who's responsible for privacy? Everybody. And you usually need the best privacy programs have somebody or a group who is responsible for it, called privacy, and they work with compliance, risk management, legal, information governance, and marketing.
Tom, based on your work and experience, who has had, and you don't need to name drop or name names, but who or which organizations have had the best or most successful implementations? This is a moving target, as we saw with New Jersey this week as well. Who kickstarts data protection, who upholds it, who manages it. Talk me through that a little bit.
One of the first thing I'd say is it tends to be the organizations that have had to address privacy in the past. And those are the ones, the industries in which privacy was called out early on. Financial services, banks, investment broker dealers, etc., insurance companies, healthcare organizations, because they already have requirements to address privacy. They had already a requirement to be transparent about the information they have, to be transparent on how they use it. So those are the organizations that I see currently have a privacy function that adopts all of this already. The other one are those who've had to work within Europe for a long period of time, because they're used to dealing with a data protection officer or somebody within the organization who reports to the highest of levels, which means they have some authority to say privacy is important and advocate for the rights of personal information for their consumers.
Thank you for that. We have a lot of records managers in our audience as well. And so how would you recommend a records manager approach privacy and promote privacy within their organization?
First of all, I feel like if we have a whole bunch of records managers, I feel like I'm with kindred spirits here, because that is my crowd. I'm an active member of RMI Speak. I publish. I love the records industry and the information governance industry. So to the information governance professionals, I want to talk and emphasize a management principle that I think is really important, something that I see is a failure sometimes in the communication between information governance and privacy. Within privacy, there's a concept called privacy by design or by default. And what that means is whenever an organization adopts a new policy, system, technology, or product, privacy is supposed to be there at the very beginning to offer their input, their commentary, and to make sure that the rights of individuals related to their personal information is accounted for at the beginning. Too often, what happens, especially in the information governance area, is IG will work with legal and compliance, create a policy, and then at the end send it to privacy and say, make sure that this is okay. And I guarantee you, if you do that, privacy is going to come back and say, absolutely not. And one of the reasons is they weren't there at the very beginning. And to a privacy professional, that is at such the core of their beliefs, of their process, that to not do that really kind of disrupts their whole flow and their whole industry and their feeling that they are important at achieving what they're supposed to achieve. So to my IG professionals, my suggestion to you is anytime you're working on a process, incorporate privacy from the beginning, because here's the thing, they're going to be your greatest advocates, because records managers have no problem getting people to hold on to records. That's not an issue. What records managers struggle with is encouraging departments and functions to dispose of something. And that's where privacy will come in and be your greatest ally.
Thank you, Tom, for that. I think it's really important to focus on solutions as well. I know that, especially with so many changes, obviously very easy to get overwhelmed, but I love that you are centering us around a common framework and a common thread. And it's really important for us too to figure out who the champions are. If it's not ourselves, as an introvert as well, sometimes I need others to amplify my own agenda. And so that's really important. And I love that you flagged that. Can you walk us through a little bit of, each section of the framework?
Yeah, so we mentioned the frameworks, and I'll work through these, and we'll end up focusing a lot on the business obligations because I know that that's really what's important. But I think it helps to talk a little bit more about the scope and individual rights and the enforcement mechanism, because then it helps you understand really why there's these business obligations and how to go about it. So, scope of the laws. I know that we have people at this webinar from different countries and different states, and some of those states have adopted a data privacy law, general one, and some have not. So the issue is, do we fall within that? With more and more states developing these data privacy laws, and more of them, on the horizon, it's so much easier just to adopt these frameworks than to sometimes have to debate whether you're actually subject to them. But the other area is that some of you are in very specific industries where you have industry privacy laws. For example, you are in the financial services, you're in the banking industry, you're in the insurance industry, you're in the healthcare industry. They have very specific ones. So it's important to know if you fall within those scopes based on your industry. But can I just have a little fun with this? And that is, it's also important to know in those particular situations that you're not subject to them sometimes too. What do I mean by that? Some of the people who are in information governance will relate to this. And that is, I work with more and more organizations that tell me have something on their schedule about HIPAA. HIPAA applies to healthcare organizations and those that support healthcare industries. I'll see organizations that have nothing to do with that try to tell me that they've got a HIPAA requirement to do something. And it's like, no, you're not within the scope of that law. So sometimes understanding you're not within the scope of the law is just as important too. Individual rights. So these are the sections of the laws that say, here's what the rights are of consumers. And while the individual words may vary, they usually fall within the same framework. And what they're trying to say is essentially is that my personal data belongs to me. You may have it, but it's my data and it belongs to me. And as such, you need to be transparent with me about that. You need to tell me what you know about me, what is retained, how you use it, how that information is shared or sold with others. You just have to let me know so that I have the right then to contact you and influence how you store it, make sure that information is accurate, and potentially stop the sell or sharing of that information with others. We'll talk at length about the business obligations, but it has to do with that transparency. You have to tell people what you're doing with that information, enable them to exercise their rights, and we'll talk about what that means. Do assessments and limit the information you collect and retain to what is necessary. And then enforcement. There's various ways that these are enforced. Why is that important? Well, sometimes knowing how something's enforced can help you kind of really focus in on what's important. Because one of the things that happens is, let me use Europe, there's a 20 million potential fine or a certain percentage of your global revenue, which could be enormous. So that puts a lot of fear in people. But understanding that there's an enforcement process that doesn't usually just start with a 20 million euro fine is important. Most of the times you're going to get some type of notification, especially if there's an agency responsible for this. They're going to notify you and they're going to ask you questions. The worst thing you can do is ignore it, because when you get those big fines, it's usually because you've ignored something or you flagrantly disregarded the law. You're not going to get a 20 million euro fine for a mistake. That's just not that way it works, especially with privacy enforcement agencies. California has one right now. Criminal enforcement agencies is another way of me saying state attorney generals. State attorney generals are going to look for the big flagrant errors, and we'll talk a little bit about what that is. But their attorney generals are, tasked with doing an awful lot, so they're not necessarily going to look for the minor ones. If you're subject to industry oversight, like in the financial industry, insurance industry, or healthcare industry, you may be subject to those. And then the potential of civil or class actions. And where you're most subject to those is going to be if your privacy notice is inaccurate compared to what you do. So we'll talk a little bit about that. But knowing how things are enforced sometimes allows you to target where your attention is.
Thank you for that, Tom. And speaking of target, we will talk through 5 business obligations that folks can take action on. Speaking of being overwhelmed, and I'm going to put my life coach hat on for a little bit here. But something that we tell customers a lot is start where you are and progress, not perfection. And I think when we were, getting ready for this webinar, especially with data protection and privacy updates constantly changing, it's really important, as you say, to acknowledge that and rectify, right? And taking action. And so ignoring it, as long as folks are not ignoring it, you're already winning. So let's jump into it. You were talking about transparency. And so this is one business obligation across states. And really industries and organizations can take action on today.
Absolutely. So this is the into action. So we're going to talk about 5 items here that you can make sure that your organization has, and it's going to mitigate much of your risks associated with these data protection laws. And the first one is to have a privacy notice. So if you go to almost any public-facing website, you're going to see on the bottom is the privacy policy. Now, here's the catch about these privacy policies. There's certain guidelines to them, and they all pretty much follow the same guidelines. And one of the guidelines is it has to be clear and concise. So if any of you receive from banking or your insurance ones, which the privacy notices come from older regulations, you'll notice that there are 5 pages with micro print on it. Well, the data protection laws that apply generally to people can't do that. They got to be clear and concise and to the point. They got to say, hey, these are your rights, and this is how you enforce them, and this is what we retain on you. And you put them in very easy to read. If you ever have a chance, look at some of the privacy policies that are out there, and you're going to be like, wow, I can actually read this and understand it. That is one of the goals of these data protection laws that are out there. The other thing I just want to point out, and this is sometimes where I find companies just fall a little short, so something to think about within your organization. And that is, a lot of your organizations have multiple public-facing websites. And oftentimes people think of the main one, but they won't think of all the other ones for their subsidiaries, et cetera, their other services. Just make sure that the privacy link is there on all the public-facing websites. The last thing I'll just show you is if you look at all the states here, it's all there. All of them have it, that there's a requirement. So you're starting to see here the similarity, not the differences.
Yeah, and it looks like Florida really is the only state that has an actual requirement for annual updates, but I would say best practice, especially as a marketer, we collect, cookies and data, and we update annually and really just frequently as much as possible as it warrants. So I think that's a good best practice for folks to think about, especially if you are itching to take action on something. This is one very tangible example. So thank you, Tom.
Yeah. And so, okay, on all of these privacy notices, so you're telling the consumer what information you have, you're telling them about their rights, but you have to enable them to exercise their rights. In other words, you have to enable the consumer to be able to contact you, ask you questions, and make requests. And there's various ways that you can do this. But I think if you're trying to create a common policy, you want to make sure that you're just incorporating all of these. Maybe an email address, a link, and a toll-free number. If you do that, you're meeting the requirements of all the various states there. But the idea here is the people need to be able to contact you and say, hey, what do you have on me? I need you to delete that information. I need to correct that various information that you have on me. So your privacy notice should have 2 or more methods to be able to contact them. And it should include like a toll-free number, a link, or an email address. Okay, so it's one thing to be able to enable people to do that. Once you receive that request, you have to be prepared to respond. And you have to be prepared to respond within 45 days. And the way to do that is to essentially have a workflow. So one of the things that you want to make sure of is that when you get that, maybe you acknowledge that you received it. So if Kim sends me a request, I can say, thank you so much for sending that. We are looking into that and we plan on giving you a response soon. The next thing that you want to do is you want to make sure that if it's coming from Kim, that you verify her identity. And there's methods to do that. There's a workflow process to do that. So you want to be able to verify somebody's identity. You want to check to see what information you have on that individual per the request, why you have that, and then respond accordingly. Sometimes the response may be, we can't comply with your request because we have obligations or there's various reasons why we have to retain it. Sometimes you're able to respond, thank you, we will do as you requested, and then you want to make sure that you actually do as they requested at that point. The worst thing you can do is to have a request and then just ignore them, because that's low-hanging fruit for some type of action.
Yeah, thank you, Tom. And you saying that, the laws are more similar than different really is very apparent here, especially in terms of time. Of course, California, 10 to 45 days, and really Iowa with 90 days, but everybody else is really 45 days. And I think that's very reasonable.
Yeah, the 10 days is just to acknowledge, and you can do that with an automatic response. I mean, I get, the same as when you're go away out of the office for a long weekend. You can have that. The purpose of that is just so people don't have to wait 45 days to find out if you ever received their request.
You mentioned potentially extending or, not or needing more time. Can you list maybe a few examples of when that would come up?
Maybe you're not sure of whether a particular law applies, or you're not sure if this is commingled with something that has a certain requirement, or you're having to do more research on that. If it's a legitimate reason like that, and that you can, sometimes we call it pass the laugh test. You can give them some type of reason for that. We're checking to see if this falls within a consent decree we have, or something like that. We're doing additional research on here. The key is communication with the person making the request.
Got it. Thank you. Data protection assessments. This is a fun one because especially in Texas, a couple deadlines are coming up at the end of the year.
Yeah, so this is a good example though of, so the general state laws are having these risk assessments, but you're seeing these in the industry too. So the Texas law that you're referring to there applies to state agencies, and they're requiring an assessment every 2 years on even numbered years. So you do have these, but the point of this is, and I think this really has to do with the implementation, and that is, we see a lot of organizations that want to have policies that are right on paper, but they're not implementing it. And the whole idea of privacy is it's not just about laws, it's about management. It's about having a culture of privacy within your organization. And the way to do that, to ensure that, is to regularly check to see how you're doing that and documenting that. And so almost not every state here, so you're not seeing this perfectly uniformed, but you're seeing a lot of states, and frankly, it's just good privacy management to, on a regular basis, whether it's every 2 years, whether it's every year, or as needed, to do some type of risk assessment, especially on heightened areas that affect consumers. Whether you're sharing the information, profiling them, or using that data in some way that could cause injury, or it's not consistent with your privacy policy. So you want to make sure that if you've got a privacy policy that's out there that's saying this is how we handle your data, and you're not handling that data that way, that's going to be potential for problems. So that's the purpose of the risk assessment. And one of the things I want to give comfort to people, and that is risk assessment is actually your best friend, because that allows people who are advocating for privacy within their organization to be able to say, we have to do this. We have to ask you these questions. We have to go to marketing and find out if they're using the data per the consent of the consumer. We have to do these various tasks right here because ultimately this is going to help the privacy function within your organization.
Thank you, Tom. And last but not least, you alluded to that a little bit earlier.
Yeah. So, and this is, why privacy has just been the best friend of information governance. When I first came into records retention industry in 2010, it was kind of under the aftershock of Sarbanes-Oxley and the Enron and the Arthur Andersen. And so there was a real concern about retaining information for the right amount of time, not disposing of information. And the reality was, while 2010 wasn't, the Stone Age, at that time you had electronic records, but the official, we used to call them official records, were oftentimes paper. And paper took up space, and paper was expensive. So disposing of it was actually something that organizations did. Well, I think most of you, if you ask yourself where your official records are, they're scattered all over, but mainly in electronic systems. And they're harder to dispose of. And so retaining it for the right amount of time is no longer a challenge because people just don't get rid of it. The biggest challenge is getting people to dispose of their information, and that becomes a bigger challenge. So the data protection laws are there to help you with that, especially as it relates to personal information. But with collection and retention, there's two different principles here. Principle one is limiting what you collect as far as personal information to what you actually need. So not taking in personal information that is unnecessary. The next thing is only retaining that personal information for legitimate purpose. So that legitimate purpose may be a business need, it may be a contractual need, it may be a regulatory need, but you want to make sure that you're not over retaining personal information. And by the way, we started off this conversation, you talked about security breaches. The best way to avoid a security breach of personal information is to not have that information. So, if you have personal information that's serving no purpose to you, and the only benefit of that personal information is for the person with unauthorized access who has nefarious intentions with that to use it, then it's a good idea to try to get rid of that personal information.
That's so true, especially with data breaches. There's a saying in the industry now that are really across companies, it's not a matter of if, but really when. And like you said, if there's no data to breach, then there are no breaches. Could you walk me through a little bit about, reasonably necessary seems a little vague and unclear and very lawyer talk. And so what, for someone like me or a records manager or a data analyst, how do we start defining that in very clear terms? And who gets to determine what is reasonably necessary or even proportionate?
Yeah, and it is very vague, and it's very vague for intentionally. Um, so, and who gets to determine that? The first people who get to determine that are the people making the policies. And so, what we do sometimes is if you have a records retention schedule, or you have a data mapping process, and we'll talk a little bit about that later. You want to identify those records or those systems that contain personal information. And then you ask yourself, why do we have this information? What is the purpose? Did we have consent requirements associated with that? But why do we have this personal information? And then be able to justify the length of time that you have. So it comes back to the laugh test. I mean, can you say this is the reason we do it with a straight face? And sometimes what we've done with clients is we've gone through categories, identified those categories with personal information, and actually just wrote 2 sentences on why we have this. Let me give you an example. For anybody in the financial industry or insurance industry or gaming, they're familiar with suspicious activity reports. So those are when you do a transaction with more than $10,000. Let's have fun with this. Let's say I'm buying a boat, and I buy a boat with $40,000 in cash. There's nothing illegal about that. That's fine. But the boat dealership has a requirement that if I'm giving them $40,000 in cash, they have to write up a suspicious activity report, which sounds worse than it actually is. It just says, Tom Corey gave me $40,000 in cash to buy this boat. And then they actually have to submit it, but they also have to keep a copy of that for 5 years. But that contains a lot of personal information. It has my social security number on there so that the federal government can figure out, why I have $40,000 in cash. And it has my birth date and various things. So there's a reason to keep that for 5 years. So you can say, suspicious activity reports. We keep this for 5 years because it's the law. Well, that's perfectly legitimate. What about maybe we have a contract with each other and you have some of my personal information in relationship to the contract, maybe, some background information that was important for the execution of that contract. And we're in the state of Indiana. Indiana has a 10-year statute of limitations for contracts. So you write something in there that says, we have this because we have contracts in states with up to 10 years statute of limitations. Okay, I can say that with a straight face. What I can't say with a straight face is, well, we keep it just in case, or you never know, or because we think our marketing people like this for various purposes. It's not within the consent. It's harder to see. I even said that, and Kim started to smile. So we know it didn't pass the laugh test, the straight face test. So, but the point of this is, it is vague. But the first people who have to kind of justify that are the people creating the policy. The worst thing you can do is just over retain something and not have any explanation for it.
Yeah, Tom, I'm laughing because this time of year, with all these New Year resolutions and hoarding and purging towards year end, I'm sure folks on the webinar, myself included, you have those jeans or that blazer or that favorite item of clothing you're just keeping around just in case, right? Just in case.
I know all about that. I've got a whole collection of pre-COVID suit jackets.
Well, thank you. I know you've walked through 5 tangible actions that folks can take regarding their business obligations. And again, starting where you are so that you have a starting point and really focusing on what is the low hanging fruit. And you've shared a couple of those. I also wanted to take this moment to answer a question that came in, actually. I was going to reserve it during the Q&A portion, but because we're talking about retention, it just feels a little more contextual and relevant. But Jeffrey from California, he is in the insurance industry here, but he asked, I am curious as to thoughts in actually implementing electronic retention within a complex environment with hundreds of repositories and how to implement retention triggers within these environments. What is emerging from your perspective as best practices in these areas?
First of all, Jeff, just a little context to that. In Europe, the GDPR was really focused on electronic systems, more the paper systems. So they could address privacy in electronic systems very early. I want to break this into two parts. First part is, especially in insurance, you have a lot of data. And the data is used for various purposes. It's used for analytics. It's used, in the insurance industry, the process of determining potential risks is very sophisticated. So that data becomes very important and very useful. Okay, first thing I would say is in privacy, there's a concept called data maps. Data maps are not the same as records retention schedules. A data map is essentially the responsibility of somebody in privacy working with IT to identify all the systems, especially those systems that have personal information, and identify what personal information they have, who's responsible for it, why you have it, and when it can be disposed. The thing about data is, a lot of times data by definition is raw information. It doesn't have any context to it. When you put context to it, it becomes information. And when that information shows a business transaction, pursuance of a legal obligation, or some type of business decision, it becomes a record. So at that point, the data itself is just there, doesn't have any type of value to it. But you want to, as a privacy professional, you want to identify your systems, what information is in there, who's responsible for it, what the controls are, and why it's being used. And that's called a data map. The next thing you were talking about is about triggers and how to do disposition, especially when data becomes a record, and maybe it's an electronic system, how to get rid of it when there's triggers. And this was, I actually wrote a paper on this, which was in IM Magazine, and it's about eliminating event codes when possible. So the two steps that I want to encourage is, number one, look at the trigger or the event code and see if there's a way around it. In other words, what is that event code, and is there a way to eliminate the trigger event or the event code? If there's not a way to do that, then the next step is ask yourself this question. Is the event code an objective or subjective standard? Here's the difference. An objective standard, anybody can be able to figure out when that event occurred. Subjective requires a little bit somebody's opinion. Give you an example. Termination of employment plus 7 years. You can determine when somebody's employment ends. There's a date, there's a document, there's something that says this employment ended January 1st, 2024. Easy enough. Final resolution. That's not easy. That's a subjective standard because somebody has to determine when was that issue resolved. So, you've got a complaint with a customer. Final resolution of that complaint with the customer. Well, I'm still mad at Blockbuster over late fees in 1997. So I'm not resolved on that particular issue based on my opinion. It's opinionated. So Jeff, the first thing I would say is see if you can eliminate the event code. And second, you have to, especially in electronic systems, you have to make sure the event code is objective, not subjective. Because an electronic system is not going to be able to evaluate somebody's opinion.
Thank you, Tom, for that. And I hope that answers your question, Jeff. And we are moving into the Q&A portion of our webinar today, but wanted to, if there's one thing that you want folks to take away, or two or three, what would those be?
Yeah, the main thing is don't panic with these laws, that they're becoming more similar than they're becoming different. And the example I'll give you is many of you operate in states, you have to manage employment records. And, if you look at employment laws, they vary from state to state, but you've managed that. You've managed how to handle various tax requirements throughout the states or even environmental requirements. And you did that usually by saying, if you're working in a lot of states or a lot of countries, hey, let's create some basic frameworks that really work with all of these states, because most of them follow similar patterns. Occasionally, there may be a variance and you accommodate for that. But the first step is to work within the frameworks. And what is that framework? Making sure that you're telling people what you do with their information, respect the personal information. In other words, create a culture within your organization that says privacy is important. Do regular assessments and try not to have personal information within your systems that you just don't need.
Just in case.
Yes.
Thank you, Tom. It looks like we have just about 2 questions that came in. Someone from Canada here. Obviously, we've focused today's webinar on states and the US map. But this person coming in from Canada, and hello to Ontario. I was born and raised in Ottawa, so shout out to you all. How should I go about applying this framework in Canada?
Canada adopted a nationwide privacy program before the United States ever did. I mean, they took it seriously, and I know they've been debating a new bill that even gives more rights. I think, though, that Canada, you can almost kind of follow the same policies or procedures similar as the GDPR, which, frankly, you're going to see a lot of similarities to the United States, the state policies to the GDPR. I'm not saying it's a duplicate, because we're not dealing with the transfer of information or anything like that in the state policies. But I think Canada has always had a stronger framework from the beginning than the states here. So I think, frankly, if you continue to follow the Canadian requirements, that you're going to be in very good shape.
They are the North Star, sounds like. Thank you, Patricia. Patricia just had a question in the chat here, so I will read it out loud for you. Is the data map really at the system level, or do you need to go deeper into the data fields to identify categories of data being held? Where do you draw the line?
I have a hard enough time getting just the system level organizations to do that, because really, do you have enough information to know that system, what information that you have in that system, especially as it relates to personal data? What are the controls? Who is responsible for it? And are you able to find that personal information and respond to data subject requests if needed? So those are the questions that you need to ask. As a privacy professional, I'm more focused on systems and areas that have personal information in it. I think IT professionals, when they think of data mapping, they have other interests and other needs. So they may go further into the systems to have a better understanding of it. But as a privacy professional, I'm really focused on just being able to identify systems with personal information, the controls surrounding that, and the ability to respond to data subjects or consumer subject requests.
Thank you, Tom. And last question, if that's okay with you. We have just about 5 minutes here. But I am in New York, and they don't have yet a data privacy law, to my knowledge. How can I prepare? I feel like it's a matter of time.
Yeah, in some ways it is. In New York, you do have the shield requirements and not the same as the data protection, but they do require the assessments there. And then for financial services, they have specific requirements there. But I would say this to anybody in the United States who has operations that go beyond their state borders, and that is these frameworks that are out there, they generally apply. So, New York may have one that comes down the line later, or Missouri may have one that comes down the line later. But it's not just about the laws, it's about good privacy management. Because I think in the United States, and certainly it's already occurred throughout the world, people want organizations to treat their private information with respect. So it's not just about, am I complying with the laws, but am I being a good steward of my consumers' personal information? And I think if you adopt these general privacy frameworks, regardless of whether your state has a law or not, I think you're going to be of good service to your clients or customers and clients.
That's a good reminder, Tom. Thank you. We have one last question before we close things out here, but from Wayne. What about testimonials? If someone gives information, is it still under this, or would it need an exception?
Yeah, I'm not quite sure when Wayne is saying testimonials. Is he referring to law firms or something under oath of some sort?
In sales, so perhaps customer's testimonial.
Okay. So one of the things about testimonials is, number one, you may have consent, so somebody's giving consent for that. And so this is the same as any type of item where you're receiving information based on consent. You just want to make sure that you're using that information consistent with the consent that the person gave you.
Thank you, Tom. And thank you, Steve, for the compliment on the good job there. Always appreciate it. And just as a quick token of appreciation, Tom, thank you so much again for sharing your time, your expertise. And as a token of appreciation to folks who have registered, we wanted to share out your report that you authored, Tom, for Harbor, and we will be sending out a link there. But how can people connect with you otherwise?
Well, I'm a director within Harbor Global, focused in on information governance and privacy programs. So they are welcome to reach out to me if they go to harborglobal.com. They can find me there. Or, if anybody, I never get to say this, I forget to do this each time. I love LinkedIn. So if anybody wants to link in with me, please feel free. I would love to connect with you.
And speaking of staying connected in New York, we, as in the Gimmal team, will be at Legal Week in a couple of weeks. And so if you are there, please reach out to us via LinkedIn as well. Say hello to Tom, as he said. And then Tom, ode to ARMA, that is how we met, because we were speaking on an ARMA webinar, just about 2 years ago at this point. But we will be sponsoring and speaking at InfoNext in Palm Springs in April. And to round out in the month of April, we will also be at ARMA Houston in Houston, Texas. And so any events, conferences we should know about this year, we would love to see you in person. And please stay connected. Thank you again, Tom, and thank you everyone for joining us live, and have a great rest of the week and rest of your day.
Thank you.